Quarter past, we're back on the saddle. I beg your pardon for being the bearer of good news. You probably do want to switch your television sets off. Otherwise, we might run the risk of seriously competing with what's happening in the United States. Massive election taking place last day today, November 3, and vote counting starts in earnest tonight and tomorrow. Might be some time yet before we find out whether or not America retains red or the tide turns to blue. That's a story for another day. What is more important now is to find out what is going on in the world of COVID-19 related businesses and the priorities for regulators in all these jurisdictions around the world. Francis in Kenya, Norman, former chairperson of the Competition Tribunal here in South Africa, independent economist, Dr. Thabile Yoka is also on the line. Of course, the moderator being the Deputy Commissioner, Mr. Hadin Rachisusu. Welcome, everybody. Welcome to the final session for the day, 3:15 until 16:30. Make sure to be attentive and ask the questions that really do matter without any fear of reprisal this time around, because you can always hide behind the fact that it was a conference and you were engaging in academic enterprise. Competition policy prioritization and implementation in a post-COVID society. Before the actual moderated session, of course, I do wish to introduce you all to Andreas Mund, who is the president of the Bundeskartellamt, that is the Federal Cartel Office in the Federal Republic of Germany, of course. We know Andreas very well as the chairperson of the ICN, International Competition Network. Let's take then, please, the keynote address now, after which we will engage with Dr. Thando Vilakazi, Dr. Francis Kariuki, Norman Mayo, and Thabile Yoka.
Dear Tembin Kosi, dear Mrs. Mansway, ladies and gentlemen, I'm very happy to participate in your virtual conference in South Africa, and I thank you very much for the invitation to take part. As the president of the Bundeskartellamt, and the Bundeskartellamt in general has a long-standing relationship with the South African Competition Commission and the Competition Tribunal. Tembin Kosi Bonakele himself is a member of the steering group of the ICN. He is an ICN vice chair, and both of us have known each other for many, many years. South Africa, by the way, also together with the Competition Tribunal, has always been a very strong player in the ICN from the beginning. It was a founding member back in 2001 in the ICN. David Lewis was also the chair of the steering group of the International Competition Network. South Africa has hosted the annual conference of the ICN. There's a lot of working group leadership in South Africa, and South Africa hosted several ICN workshops. So you can see easily this important role that South Africa has played in the ICN, but not only here, also in other international fora like UNCTAD or the OECD. So this is why I'm all the more happy to contribute today, given this long-standing international relationship between us. We are in the middle of the COVID-19 crisis. South Africa has seen one of the toughest lockdowns in the world, has lost many jobs, although the statistics today look better than in other countries in South Africa. COVID-19 is casting its shadows on everything. It has triggered an economic crisis around the world. It is not just an economic crisis, but it's a crisis for societies that are confronted with distortions they have not seen before in this way. Our experience over here in the Bundeskartellamt is, in these times, nobody calls for more competition. Instead, people call for a strong state. And I agree, in these exceptional times, the state cannot stand at the sidelines. States have to act. And competition agencies have to react as well. They have to act in this changing economic environment. As competition agencies in this crisis and during the crisis, we have tried to take a joint approach in various international organizations, in UNCTAD, in the OECD, and of course in the International Competition Network, the ICN. In the ICN, we have reacted very quickly. We have set up a joint statement by the steering group with considerations that related to competition law enforcement during the crisis. Our message was twofold. The first message was that we were ready to adapt our approach in these unusual circumstances. But the second approach was that we reaffirmed the relevance of competition to economies in crisis, and that we urged the members of the International Competition Network to remain vigilant, to make clear and to send up a strong message that competition is not the problem, but it is part of the solution. So all areas of our work are affected by this COVID-19 crisis, be it antitrust, be it merger control, or abuse of dominance. We should not let the crisis change our priorities. In some areas, we have to take a new approach. In some areas, we even have to sharpen our focus because the crisis accelerates problematic developments that have started already before. So I quickly want to take a short look at the various fields of competition law enforcement during these times. My first look is on the cooperation among companies during the crisis. Over here in the Bundeskartellamt, we have a long tradition of giving advice to companies what is allowed in terms of corporations and what is not allowed. Now, during the crisis, of course, we had to give even more advice, sometimes more intense, sometimes it was a very urgent case, and sometimes it was even complex. But in the beginning, there was lots of cooperation among companies, for example, with regard to logistics. Later on, there were other questions that we had to solve. For example, how to reactivate a value chain after the value chain has broken down completely during that crisis. From a legal point of view, companies had to cooperate much more during that crisis than before. So there was a strong demand to give advice by the Bundeskartellamt. We did not take a lenient approach with regard to corporations, but of course we took into account the specific circumstances during this exceptional urgency. If markets don't work, competition has to be assessed differently. So what was important for us was that the corporations were appropriate and proportionate. It was important that they were non-discriminatory. And of course, it was very important that they were limited in times. So that sent out the strong message: you are allowed to cooperate, but please, no cartel agreements during that crisis. What was difficult, of course, and that remains difficult until today, were dawn rates. What remains difficult is to impose fines because companies claim their inability to pay a fine. We have to cope with this. We have to develop concepts for that. But I think we are on a good way here. Another issue we have to take into account is state aid. We do not have competences in state aid as Bundeskartellamt, but of course, state aid is a competition issue. I agree, again, that the state cannot stand at the sidelines in these difficult times. But it must also be clear that state intervention, state aid, is always difficult. It's always problematic because it distorts competition per se. That is easy to say. Some receive state aid, some don't. Some benefit from this advantage, some don't. So you have to be careful about that, and you have to give state aid with certain measures or under certain conditions. And I think these are the same that are valid for cooperations among companies. State intervention needs to be fast and focused. It needs to be proportionate, plus it needs to be limited in time. And I think if this is obeyed, if this is taken into account, state aid and state intervention is something that might be feasible under these conditions. Another area of our activity is clearly merger control. It is our task to prevent markets from dominance. We had a sharp decline of merger filings at the beginning of the pandemic, 50% alone in May. Now we are back to normal almost. We have seen difficult cases. We have seen merger cases with a high risk of insolvency. We have seen cases where it was difficult to impose or to enforce remedies. So here we had to be flexible. But one thing is also for sure: there cannot be a pandemic bonus in merger control in general, because a crisis is temporary, whereas mergers change the market structure forever, and we can only run behind it afterwards with abuse control. So no crisis bonus in merger control. One focus remains, and this is digital markets. Digital markets are defining the agenda of competition agencies around the world, and even more so during the COVID-19 crisis. Platforms have even further expanded their market power. Amazon has tripled its net income in Q3 of 2020 to 2019. Google had a rise of the net income in Q3 by 59% and Facebook by 29%. We have to act in this respect, but we act in a challenging environment. We see a rapid technological development. The issues are embedded in policy considerations. We see a touch of protectionism around the world. And we always work to a certain extent at the intersection with other areas of law, with consumer protection law and data protection law when it comes to enforcing competition law in digital markets. Fortunately, there has been a huge groundwork by competition agencies around the world, again, embedded in our activities in international organization. And here again, the ICN has introduced this topic at a very early stage. I remember our Sydney annual conference back in 2015, when we have done a special project on online vertical restraints. Afterwards, there was a growing number of projects and sessions at each annual conference in Singapore, Portugal, India, and Colombia, culminating in 2020, where during our first virtual annual conference in the ICN, the digital economy was an overarching topic during the whole conference, with 2,500 participants only on the first day. There have been successful cases around the world. I can here only speak for the Bundeskartellamt. We have seen successful cases against Amazon, against Facebook, against Booking, and I'm very happy to see that the Facebook decision of the Bundeskartellamt has made it into the excellent report of the South African Competition Commission called Competition in the Digital Economy. We have seen cases on price parity clauses vis-à-vis Amazon, vis-à-vis large online hotel booking platforms. And we have learned a lot during that time. We have learned, as competition agencies, how to deal with data-driven market dominance. New cases make the headlines today. So, despite all these cases, also the new cases, we also see around the world that competition law might need at least some adjustment. This is why you see lots of legislative initiatives here in Germany, in Europe, and in other parts of the world. The digital economy will be an important part of this conference during day 2, and I'm sure that this conference will give valuable input on this topic. To conclude, let me mention one last topic, that is the discussion on sustainability that is gaining speed. It seems that the pandemic has made us more aware of our vulnerability. The sustainable use of resources has become one of the major issues of our time. And competition authorities, of course, come into play when companies need to cooperate or say they need to cooperate in sustainability matters. So that is the huge question also for us as competition agencies, how to take into account sustainability aspects in competition assessment. There's a broad debate on this going on. Here in Germany, we just had a huge conference on that with our academics from German universities. And this will be a special project for the next ICN annual conference in Hungary in October 2021. So finally, to really conclude, I have 3 messages today. First message is that we as enforcers, we need to take into account post-COVID scenarios even in the middle of the crisis when we apply competition law now. Secondly, the crisis affects all areas of our work: antitrust, merger control, and abuse of dominance. But our rules need and allow us to be adapted to a changing environment if necessary. And finally, my third message, we need to be focused and to keep focused. We need to remain vigilant as enforcers, especially in the areas of merger control and in the area of abuse of dominance. The good news in these times is that you can count on the international community. Competition agencies are not doing this alone. We have strong international fora like the ICN, the OECD, and UNCTAD. And I'm pretty sure that if we all try to be together, to get together in overcoming this kind of crisis, not only in the area of competition, in all kinds of areas, we will be much more successful than doing it alone. I thank you very much. I wish you a very fruitful event. I'm absolutely sure you will give valuable input to the international debate on these difficult topics. Again, it's a pity I cannot be with you physically, and I send my best wishes to South Africa. Thank you very much.
Thank you very much, Andreas, for those remarks. We will now move on to our panel discussion. And to start this, I just have some thoughts I wish to share with you to situate the discussion. So in UNCTAD's 2020 Trade and Development Report themed From Global Pandemic to Prosperity for All, Avoiding Another Lost Decade, Secretary General Mukisa Kidui makes this observation. COVID-19 has served as a reminder that we live in a closely interdependent world that brings opportunities but also carries dangers. It has, just as importantly, shed light on a whole series of pre-existing conditions, from heightened inequality to unsustainable debt and rampant environmental destruction that were left unaddressed after the global financial crisis. The world at the end of 2019 was, in truth, a good deal more fragile than many were willing to acknowledge. As a result, COVID-19 obliges us to think carefully about what makes for healthy and resilient communities at the global level as much as the local level, and take to heart the lessons we have learned in the last decade. And now, equally, competition authorities had to respond to the economic disruption of COVID-19 crisis, with many granting exemptions to firms to ensure coordinated responses, and some taking action against price gouging. Looking ahead to a deep global recession and devastation to sectors such as the airline and tourism industries, there are likely to be challenges around failing firms, industry restructuring, and calls for cooperative arrangements in rebuilding the economy. We have started with quite insightful input from the president of the Bundeskartellamt, Germany, and chair of the International Competition Network, Mr. Andreas Mund. He emphasized the need for competition authorities to stay focused on priorities, but if markets don't work, competition will have to be assessed differently. And noting also that competition regulation may need some adjustment to fully address challenges brought about by the COVID-19 pandemic. This session will therefore focus on where competition authorities should be focused during the post-COVID period and what approaches should they adopt in addressing these challenges. To dissect the challenges presented by the COVID-19 pandemic in the world economic order and competition authorities, especially those in developing economies, we have a distinguished panel of speakers. And given their respective roles in shaping competition regulation, they need no introduction. We have Acting Judge Norman Manoim, who is Acting Judge of the High Court in Gauteng and the former chairperson of the Competition Tribunal for a decade, who is joined by Dr. Thando Vilakazi, an Executive Director of the Center for Competition Regulation and Economic Development, and a part-time member of the Competition Tribunal, and Mr. Wangombe Francis Kariuki, who is Director General of the Competition Authority of Kenya. Our discussion will not only focus on competition regulation, but also broader policy considerations. And to complete the panel, we are pleased to be joined by Dr. Tabi Leoka, who is an independent economist and also serves in the Presidential Economic Advisory Council in the government of South Africa. Time permitting, we shall take a few questions at the end, so please post your questions on the chat. Let me start with Dr. Leoka. We hear a lot of numbers around decreases in GDP with 8% contraction predicted for 2020 and the substantial loss of employment. Given the devastation we are seeing, do you think there will be lasting structural damage to the South African economy, as well as other developing economies, or even the global economy? Is the economic recovery a matter of time, or are there areas that will never recover? Over to you, Dr. Leoka.
Thank you very much for the introduction and also the opportunity to speak to at the Competition Commission conference. Very good questions. The South African economy has been ailing for a very long time. Even before the pandemic, we were actually in a recession. And the numbers that have been punted about in terms of economic growth have ranged from 8% to 10%. I currently forecast economic growth for this year to a contraction of around 9.2%. And I think that the risks are on the upside. So when we look at what is developments that are happening in Europe, we realize that Many of our trade partners are, their borders are shutting down. They're going into their second wave of this pandemic, and this will impact on the global supply chain. And this will definitely impact on our sectors such as manufacturing and mining, which together account for over 25% of GDP. So we will struggle to recover. And if we look at what happened in the global recession of 2008, 2009, it took us around 5 years to get back to pre-Great Depression levels. And we then had lost about just over 1 million jobs. And this time round, in the second quarter, Stats SA revealed our unemployment rate, and we now know that 2.2 million South Africans are unemployed. And the numbers don't look good, because if you look at employment, I think around about 39 million South Africans are within the working age population. Out of that, 14 million South Africans are actually in employment, and 18 million South Africans are unemployed and rely on the social grants. So as we recover, we need to correct that, and we need to ensure that our recovery is inclusive. The other thing that has changed, unlike the Great Recession, is that we have changed. The world has changed so quickly in the past 6-7 months versus the past 3 years. The previous speaker talked about companies such as the fintech companies doing exceptionally well during this period. And unfortunately, what that has done is that we're seeing what is now called the K-shaped recovery. So we will see huge unemployment and inequality, not just in South Africa, but globally. And so the arm of the K is those who have invested in the stock market, those very wealthy people whose wealth has quadrupled during the pandemic. And the leg of the K are those people who have found themselves vulnerable, unemployed, and unfortunately, they are the bulk of the population, even globally. So as a community, a global community, this is what we need to look at. How do we emerge out of this pandemic as equals? How do we ensure that the inequality gap is closed? How do we ensure that there's equity even in those companies that have done very well? We need to close the inequality gap, and they need to play a significant role in closing this gap, because to be honest, they have created this widening gap and this K-shaped recovery that we're starting to see. Where does the future lie? I think that unfortunately, there are companies that are not going to fare well. Those companies are those companies that are not able to get funding, companies that are not agile, companies that haven't been able to pivot. And we've been talking about these words throughout the pandemic, and as if everyone can pivot and everyone is agile. And unfortunately, that's not the case. The other thing is that we need a different skill set. I think that for the past, almost a decade, we've been talking about AI and fintech and digitalization, but we haven't really adopted it as much as we should have. And now I think that we're seeing companies that are adopting this faring better. And in terms of even being protectionist, and we're seeing that globally as well. And when companies start replacing human labor for machines, that also has negative consequences for the unemployment rate. So I think as a country, we need to be aware of it. We can't be laggards, because this is a global phenomenon, and this is a new paradigm. But then we need to ensure that as we move forward, it is inclusive and everyone has room to play within this new paradigm. The other thing that concerns me in terms of how we're going to develop is the lack of finances that we have as a country. About last week, we had the medium-term budget policy statement, and again, we had very negative numbers in terms of our fiscus. We have increasing deficit and also debt to GDP numbers. The gap between the revenue and expenditure is widening, and we need to shrink this deficit. And I don't think that's one of the biggest challenges, because we're relying on wages and the wage bill to shrink without having agreed with Labour on how we're going to do this. So I think that is one of the biggest risks, because I don't see us shrinking this deficit. And what that does is that currently the composition of our expenditure means that it's crowding out investments and then crowding out social investment. So as we are emerging, as we emerge out of this pandemic, it's going to be very difficult for us to do so without the financing to do so, and especially the social financing that typically funds education, social development, infrastructure development. And so this is, again, where the private sector needs to step in and ensure that there's this partnership between the private and public sector to invest in South Africa and invest in social infrastructure and also bulk infrastructure. So and there are lots of uncertainties. There are a few opportunities. We have to think outside the box, but we need to ensure that as we develop equitably as a country, but also as the global community.
Thank you, Dr. Leoka, for the opening comments on the state of our economies. Now, let me turn to Dr. Lakas. Policy coordination will be critical for economies to achieve economic recovery. How can competition, industrial and trade policies be used together to drive economic recovery?
Thank you, Deputy Commissioner, for this opportunity, and to the Commission for a great program thus far. I think that it's a very tricky place that we're all in. I think Dr. Leoka describes very well the kind of quagmire that we're in, right? Amongst other challenges, there's this kind of pressing imperative to have or to protect jobs, to protect kind of what productive capabilities do exist in the economy. And my worry with all of that, before I get into my kind of specific remarks, is that that implies a tendency to focus on the short term. Of course, it implies a tendency to lean towards protection of current jobs, incumbent operators, and the kind of current structures of our markets that have in fact got us to this place in the current crisis where there is no dynamism and there wasn't resilience because too much of our economic activity was concentrated arguably in the wrong places. Frederick Jenny makes this point in his recent article as well, is like the fact that we've allowed the markets as they have to allocate resources as they wish has meant that many economies didn't have the scope to maneuver to actually respond in terms of being able to produce goods that were required in this crisis, right? And so in many ways, it's kind of highlighting that markets work, but they actually need to work, as the Judge President was saying earlier, for more of the population. And they need to drive towards different objectives. I think there's a tendency to focus on stability in the current environment, but I think there's a few other things that I would suggest are also very important. In this, I would include a few different things. I think that if we're to build a resilient and dynamic economy over time, and this cuts across policy areas, then I think you have to focus on aspects such as diversification. You have to focus on how do you create channels for new ideas, new skills, and new business models to emerge, right? And that means taking risks and making certain short-term sacrifices, which fortunately I don't have to make as I'm not in the policy position. But speaking of who is in the policy position, I think it's a significant moment in the kind of South African context, at least, that just recently the ministry of that the competition authorities fall under has been redefined as the Department of Trade, Industry and Competition. Now, this may well be quite symbolic, but I also think it sends a very important message about the fact that competition law specifically is going to play should play a very important role more broadly in cutting across policy areas as well. The window is there, and I think there needs to be focused more, at least, on developing a more broader national priority, and I would suggest even a policy framework about how are we actually going to achieve inclusion. I think it's been left to anyone's guess in terms of how we're actually going to do it. And unfortunately, it means that often the Competition Commission has had to bear the burden of achieving this thing. More broadly on policy coordination that's required, maybe just to make some other remarks, I think that one of the challenges in South Africa, and we've seen this also in other countries in the region that we do research on as the center, is that regulatory toolkits often don't pull in the same direction. So you might have the competition authority with a particular focus on public interest and small enterprises and inclusion, etc. But if you look at your rules of the game in energy policy or in telecoms policy, etc., they do not prioritize the same objectives. And I think this is a fundamental flaw in the coordination between our various policy areas, right? Because it means that you have these kind of policy directions that are different in different areas, which is a significant waste of time and resources. And I think it's part of explaining why we are in the kind of troublesome situation that we're in currently. I'll make maybe just two more points, Chair, if that's okay. I think that there's a very interesting and important role, centralized role that the competition authorities can also play in terms of policy design. And this is not an area where we kind of traditionally associate competition authorities. But if we think back to the fact that, for instance, there was a time, and I forget the year of these cases, where there was a huge problem with tender rigging, bid rigging in government contracts. And the competition played an important role along with the National Treasury in shaping how you could make the rules for tenders less likely to be subject to tender rigging. Now that for me is policy making. And I think the authorities broadly, especially in the current paradigm, can play a far more dynamic and active role in advocating in various different ways for measures and policy directions that open up the economy and allow for a bit more dynamism and rivalry. And then I think lastly, just to say about coordination, as much as we kind of, this environment forces us to think big about a lot of interesting concepts, I think it's also very important to get the basics right. When we speak to a lot of companies in the economy for different research projects, the same issues keep coming out. We cannot get funding fast enough. The form of funding is not appropriate. Policies are not in our favor. Regulatory processes are not quick enough. Departments of government are not talking to each other, etc. Now, we don't need COVID to tell us this is the problem, but I can tell you now that if we don't solve some of those problems, we're not going to solve some of the challenges, especially for smaller firms, that COVID brings to us. And I think it's probably a good time to even draw lessons from the very well-coordinated policy response that we've seen on COVID to a wider, and broaden that to a wider kind of economic policy approach. I'll stop there. Thank you, Chair.
Thank you, Dr. Vilakazi. I think that was quite hard-hitting, if I may say, because it seems to me we know the challenges, and Dr. Leoka, emphasized on this K-shaped recovery that is just not sustainable. So I think a lot of food for thought there. I will now turn to competition regulation. And I shall now bring in Acting Justice Manoy on the question of the form of major regulation in a crisis we face today. Should measures be considered any differently in the context of the economic crisis? Do we put more weight on public interest considerations such as employment, or do we apply the substantial lessening of competition test more strictly in order to avoid any lasting anti-competitive consequences? Justice Manoy.
Thanks. My apologies for not having my video. There is some technical problem that is beyond my talents to actually solve. So if you don't mind seeing a dark screen, I will try and answer the question. Look, I think as far as the legal test is concerned, unless the legislation changes, your legal test remains the same. So what changes under COVID is how you examine the facts and how you give weight to different facts that have got. So the big problem that you're faced with is what's temporary and what is less temporary, for want of a better expression. In other words, how much of your typical merger is going to be a situation where emerging parties come to you and they say, please let our merger through, even though you may be concerned about increasing concentration and lack of competition. We are saving jobs. And so you've got to actually work out how to evaluate that particular situation. In other words, what you're being asked to do is to trade off an increase in market power with a decrease, with a public interest, a positive public interest. Now, that's a question of how you evaluate the facts. So what you want to really do is saying, well, the firm is allegedly failing, the target firm, let's say. Is it failing on a temporary basis, or is this a more permanent structural feature? That's going to be very, very difficult to evaluate, because a lot of the situation, as it were, the macroeconomic background to you is in the government's hands or is in the disease's hands. It's not up to the Competition Commission to make that evaluation. But there are certain small things that one could look at. For instance, is there a difference between a target firm that sells coffees and a firm that sells cars? It may well be that during the closure period, both these firms had to close for a certain period of time. But it's fairly likely that the firm that sold coffees is never going to regain those sales and may genuinely be failing. But the firm that sells cars may be having an opportunity once it's reopened to sell those cars that weren't sold during the time. In other words, its claims to be a failing firm may be less compelling than the guy who sells cappuccinos. And that's the kind of analysis one needs to take in that situation. Then we look at the claims made on the public interest side. It may well be that people will say, we're going to save this firm, we're going to save some jobs, but don't make us save all the jobs, because there'll be no point in actually saving that firm. That equation is going to be very, very difficult to actually decide in how you do that. But I would fall on the side saying, if you're going to if there's a danger that there is a market power employment trade-off, and if a firm is likely to acquire market power, at least temporarily, then it must pay the price in actually a stronger public interest, in this case an employment condition being imposed upon them for a period that is least likely to occupy what is the balance of the likely COVID period. Then the question is whether you, in a sense, you've got to let the merger through. It is going to be a lessening in competition. They are willing to give employment undertakings, but should you still under those situations trade off the competition problem? After all, you're a competition regulator if you're the Commission or the Tribunal. I would say in those situations, it's very, very difficult indeed. But it may well be that one wants to introduce structural separation for a time being. In other words, say to the firms, look, you can go ahead with the merger, but the target firms, either its brands or it's certain of its branches, must be held separate within the merged firm for a certain period, in which you assess after that period. You require them to, as it were, re-notify and advise as to whether there's been new entry into the market. If there has been, that's fine. If there hasn't been, you might want to consider whether prices have gone up during that period, and there's justification in telling them to either sell off the brands or the held offs or the other branches that have been held off until that period. What it does raise, of course, is the fact that you've got to have two inquiries, which make it more burdensome. But it may be in situations where the market power problem is particularly compelling, but there's also a very compelling case for saving jobs, that you use the whole separate thing as a temporary remedy and look at it again once, as it were, the COVID crisis has gone. Thank you.
Thank you, Justice Manoy. It's quite clear you are calling for creative regulation, some form of creativity in navigating our way out of this crisis. Let me rope, on that note, rope in a Director General Kariuki. An important area of debate is whether competing authorities should prioritize certain types of enforcement, such as measures, given the likely greater prevalence of rescue measures, or even enforce with more or less vigor depending on who you speak to. What has been the approach of the Competition Authority of Kenya?
Thank you, Hardin, and I wish to thank the Competition Commission of South Africa for our continued cooperation in these discussions, especially during this COVID-19, and looking forward to continue with the post-COVID-19 discussions. Hardin, I would like to share with the audience that Kenya's merger regime is suspensory in nature, that parties which meet the thresholds, they have to notify and they have to undergo the due process before they consummate the merger, even during this time of COVID-19. So I would like to say that it's not a merger, it's not a matter of prioritizing, it's a matter of whether we should fast track those mergers, those sectors which have been affected by COVID-19. The other issue is that I would like to indicate is that merger or structural approach to competition maintenance in the markets has not been very eminent, because you realize that most of the mergers are approved. Over 90% of the mergers which come to the authority are approved. So from where I stand, I know it's a bit provocative that mergers structural approach to ensuring that markets remain competitive has not been very eminent. So that is what I would like to say. However, having said that, is that as I've indicated, yes, we are fast-tracking mergers in certain sectors which have been affected by COVID-19, and they have also to undergo the due criteria, that is substantial lessening of competition, and also the public interest criteria. But if you can recall, what I've said is that the structural approach has not been very eminent. It means that during this COVID-19 is that we are more interested with public interest criteria in ensuring that we are maintaining the competitive markets and also maintaining the workings of the markets. You have asked me the issue in regard to rescue mergers, that is the failing firms. And I've indicated that they have to undergo the substantial lessening and also the public interest. For example, the authority has to seek evidence that the firm is going under, that the firm is under distress. And then after seeking that evidence and it's presented, then we have to check whether the acquirer is dominant. And if at all it's dominant, it does not stop there. We have to ask ourselves, is that was he the only person to acquire the failing firm? And if at all he was the only person to acquire the failing firm, is that we can go ahead, and we have gone ahead and approved, however, with conditions that, for example, you have to continue supplying the goods or the services the failing firm was supplying. Number two is that you have to maintain the suppliers who are supplying to the failing firms. And then when also we come to employment, is that you have to continue employing, but obviously is that we have to bear in mind that there is duplication of positions, and therefore we cannot force them to employ all the parties. But also employment goes beyond human capital to the assets which were under the firm which is failing. In terms of the sectors which we are realizing that we have to consider this, it's the hospitality, the hotel industries. Some of the hotels are failing. The supply chain is collapsing. And also in terms of the schools, the private schools, Kenya has been on lockdown. The schools have been closed since March. this year. That is about 10 months. And therefore, private schools, we are going to see a collapse of private schools. And if at all there is a now private school which can take over the other private schools, we have to look at each and every case to ensure that the distance which children travel is still maintained or minimized. But having said that, is that we have to be very aware also that the existence and the opportunities for killer mergers is with us, especially in the digital economy, where we have seen that the digital economy is expanding and there are opportunities. And we have to realize that some of the incumbents, especially in Kenya, you know who are the incumbents, they have to be focusing on these upcoming farms so that they can still continue maintaining their market power. So that is the balance we have to undertake. And what my parting shot is that the market structure approach has never been very eminent, and it has been eroded further with COVID-19, but the process and the procedures still maintain, and it will be on case-by-case basis. Thank you.
Thank you very much, Director General Kariuki. Indeed, I think it's quite evident that the public interest clauses and provisions that we have adopted in our laws and principally on the continent go a long way in allowing us to respond to this crisis. Dr. Leoka, you have heard of approaches to competition regulation in major regulation by forces, but now SMMEs are commonly seen as one of the biggest casualties of the economic crisis we are facing. In the competition space, we see SMMEs as key to entry and growth, and ultimately healthy competition in markets. What has government done to support SMMEs, and what could it have done better?
So I think even before the pandemic, not enough was done to support small and medium-sized entities. There was always an issue of how do they access markets and also access funding. And so when the pandemic struck us, it was very clear that these very vulnerable entities are going to be the first to be impacted. And indeed, within a month or so, many of our small and medium-sized entities closed shops. And this is unfortunate because they do also employ, and they should actually really be the backbone of the economy, but because of the structure of our economy that is heavily weighted towards, the oligopolies, these entities have always had to struggle, and they've done so even before, before the pandemic. What the government has done to try and help these small and medium-sized entities is, I think the first one is to allocate about 200 billion rands towards the loan guarantee scheme. And to be honest, I was never a supporter of the loan guarantee scheme. We've had this before in South Africa, and the uptake has been very low. And the uptake, again, is very low. Just to give you a number, out of the 200 billion, only 100 billion was guaranteed by National Treasury for the SARB to be the undertaker of it, and only about, I think, 16 billion has been extended to small and medium-sized entities. So out of the 200 that's been announced, only 16 billion has been injected into the economy, and that is insufficient. The other funding that we had was that small and medium-sized entities could access funding from small business department and also from the IDC. But again, they had very strict rules the informal sector couldn't tap into this market. Many of your small entities could not tap into this market because they're typically very informal. They don't have the requisite tax numbers. And many of their applications, or all the applications, actually had to be done online. So again, discriminating against many of our small and medium-sized entities. The other one that we had was the UIF surplus fund that was also put aside. And we know what happened at the UIF. There has been also corruption there, and the process hasn't been very smooth. And we also had a temporary tax relief, and that has also helped some companies. I think, we could have done better, and hopefully this pandemic has revealed certain fault lines, and definitely the support of small and medium-sized entities needs to be taken seriously for this economy to recover.
Thank you. So in short, really not enough, but I suppose government can do better. And now turning to Dr. Vilakazi, what role should competition law and enforcement agencies play in driving economic recovery?
Right. Thanks, Chair. I'm really excited that at a competition law conference, we're not just kind of talking about the things we usually talk about at competition law conferences, but we're actually expanding the frame of reference and the issues we're considering to a much broader set of issues. And I think this is precisely the point. This is where we should have been probably 20 years ago, right? And this is because we need to kind of be reminded as well why these pieces of legislation exist. And they don't exist for their own sake or to keep a few of us busy in this kind of competition community. We are interested in the outcomes that the competitive process can bring throughout the economy, right? We're not interested in merger regulation for its own sake. We're interested in it because it's part and shapes the trajectory of economic development in a sector, in an industry, or whatever it might. And it's important to remember that. Maybe to borrow the words of the Springbok coach, which now I'm going to refer to as an economist, Rassie Erasmus, in the recent documentary, Chasing the Sun. He says, we've got to remember to keep the main thing. And I think it's important, and these discussions force us to remember why competition laws exist and why we have to have these discussions. It's not just about whether or the kind of more technical debates around our comparative jurisdiction in terms of outcomes compared to other countries or Europe or whatever it might be, which are all important debates, but because there's a wider objective that the Act seeks to achieve. And I went back and looked at this again. It reminds us that it's not just efficiency. Efficiency is one of other goals, including increasing capability in the economy, building capabilities, fair participation, consumer benefit, etc., redress, right? And so we shouldn't be uncomfortable when we force the competition policy and law to have to consider these other issues. And so I think it's really important that we're having these discussions. So that's maybe the first point to make, is that that there's a broader role for competition agencies to play, full stop, right? I think that in many ways, though, upon reflection, I think authorities, and this applies across the region, not just in South Africa, should continue to do precisely what they have been doing as well. Right? So it sounds like a bit of a contradiction, but I think there's elements of the way, for instance, the Kenyan authority, but also the South African authority, and a few others as well, have actually implemented their mandates. The focus, for instance, on increasingly in the South African area on participation, barriers to entry issues, right, is especially important. The advocacy, not only within competition space, but also to advocate for competition principles and inclusion principles in other policy areas is especially important, right? Especially because, at least in the South African case, and I think this is true in Kenya as well, the authorities hold a unique position in that they've demonstrated strong technical capabilities, independence, reliability, and extreme ability to deliver in economies where many government departments are failing or struggling, right? And so that's lent us, if you want to talk about the broader competition community, the ability to then shape debates in other areas. So we've built the credibility to start to contribute in other policy areas. And I think driving an agenda of inclusion for competition authorities is especially important. I don't think we can afford to keep quiet about some of these issues, right? If we think about the fact that it's taken us so long to arrive at the exclusive lease settlements that have come out of the grocery retail market inquiry, even some of the issues, even some of the findings around the data cost inquiry, etc., right? If there was coordination, if there was understanding of the principles of inclusion and participation in other policy areas, maybe a simple policy decision in each of these areas, maybe by the telecoms regulator, would have resolved the data cost issue 10 years ago, right? But no, we waited for a competition process. We waited for this process. And I think it's because there isn't a wider conception and understanding of how important these issues are for longer term dynamism. And it's not a thing that we prioritize in our research just because it feels nice to have an inclusive economy and include SMMEs, etc. It's not a feel good thing. Dynamism comes from participation and rivalry. Dynamism does not come from a highly concentrated economy focused only on mining and the same lead firms as it has been over the last 25 years. That's not how you're going to build economic resilience. Chair, I want to make one more point in two parts. I think there's a very important role for market inquiries in terms of what authorities have already been doing, because they seem to be able to unlock areas that other policy areas are probably struggling to do with the superior technical ability of the competition authorities. So I think that's very important. And lastly, basics. Research and knowledge dissemination plays an incredible role, perhaps understated, I think, in our jurisdictions in the region. I think Kenya and South Africa are commendable, amongst a few others, for actually publishing information about cases and informing society about impact, demonstrating impact of interventions is especially important. It's the last thing you want to do when you finish the case, to go back and study it again. But it's probably one of the most important things that competition agencies should be doing, because other policy areas then leverage that knowledge base to have far more impactful interventions. And we've seen this. Case studies are there and also available in our book as well with Simon Roberts and Sumaya Goga, which speaks about precisely these issues. Thanks.
No, thank you, Dr. Vilakazi. Clearly, you say we should keep the main thing, at the forefront. And it's good that Rassi Erasmus won us the World Cup. So maybe this is a positive sign that if we follow his philosophy, we could go further. But also, there is really a lot for competition authorities to think about. Coordination, amongst different regulators, and staying focused. And I think your inputs are quite pointed, towards that direction. But now, let me go back to Director General Kariuki, because you are essentially provoking authorities to think outside of the box. A key consideration is what the trade-off is between the short-term and long-term. Some of the policies and actions, such as exemptions for coordinated behavior and trade protectionism, are usually seen as negative and undesirable policies, but necessary in the short term, given the economic context. How can governments weigh this up, and of course, by extension, competition authorities?
Thank you, Hardin. And it's quite a difficult question, especially this time of the situation we are facing now in the markets. But I have to say this. Exemptions during a crisis are a positive irritant, which we have to live with them, but for some time. Just like the way we spray insecticides in our homes, we live with them for some few minutes and they help us achieve what we want to achieve. Based on that reality is that I have to say, as competition authorities, when we are according parties the exemptions, we should have a baseline, the status of the market at that time, the relevant market. What am I saying is that we should know what are the prevailing prices at that time. What are the prevailing outlets at that time? The essence of this is that with exemptions, if at all we grant them, that the markets do not go below the prevailing or the status of the markets by the time you grant those exemptions. Those are what I would call irreducible minimums. And what Tando said is that market inquiries are very key at the moment, is that we have to approach and understand the status, the state of play in those markets before we grant the exemptions. For example, in the airlines, I know we are going to face a lot of requests for grant of exemptions in the airlines. For example, in the evacuation of cargo for our agriculture produce, the number of flights may decrease after the exemptions we grant. But we have to have also that we have to create minimum warranties the parties have to meet. That you have to meet this number of evacuation, the tonnage, you have to have this number of flights, and also the pricing should not go below or go above when you are coming to us to seek for exemptions. The other issue is that the exemptions should have very strict sunset clauses, that they don't go beyond a number of years. Dr. Tabi indicated that the economic crisis may take about 5 years. And I would suggest that if at all we are granting the exemptions, that they are based on those 5 years, and after the 5 years we revisit. And also in terms of when we are granting the exemptions, there has to be increased participatory, so that at least you can approach the whole issue from an informed position and what is happening, as we always call it, on the ground. The other issue is that I always advocate for is that we have a clear criteria. So that is non-discriminatory approvals of exemptions. This is what COVID-19 was doing. So if at all the exemption is supposed to help that situation that we don't have the decline, then I'll be inclined to give the exemption. Then the other criteria is promoting technical or economic progress or stability in any industry. Industries are facing challenges. Is the exemption going to facilitate the technical progress within this industry? And then the last one is the benefit of competition. That is the other criteria we have to look at in terms of whether it's outweighing. And when we have three criteria met and you tick, I'll be comfortable to give the exemption, and especially in the area where we are supporting the vulnerable members of our society, especially the poor. Thank you.
Thank you very much, Director General Kariuki. Clearly, you're right, and competition authorities have to know the baseline. And this is your message, and it's a very, very important message. Acting Justice Manoim, you have served for 2 decades at the Competition Tribunal, and at the height of the 2007-8 financial crisis, from which some economies are yet to recover. What initiatives must the Competition Commission, as well as other competition authorities, prioritize to promote economic recovery and the building of the economy?
Well, I think when everyone talks about prioritize, it means that you've actually got to make a choice between what you should do and what you should not do. So even though your statute says you should be looking at something or other, you may have to make a prosecutorial decision not to do that particular thing. So let me start off on the negative and saying what you shouldn't be doing. In the first place, and I know it's not the Commission's choice, this is the choice of government, is that what you should not be doing is having to police exemptions. I think now that we're on level 1 of the disaster management regulations and the economy has largely opened, there is no cause for a special exemption based on COVID. So that should go, because otherwise you're just creating a fruitful area for, as it were, meeting place between competitors, and the conversation can veer off from the good public interest that it started off with to something that they shouldn't be doing. Second, and this is going to be more controversial, is the issue of excessive pricing. Yes, there has been excessive price gouging, I would concede, during this period, but the resources put into those cases is disproportionate to its effect on the economy. I mean, I've just looked at some of the cases that you've got, which are, at the end of the day, revolve around what is a very small area of commerce. And so the resources that you've put into that are being diverted from something else, or something that is not, in a sense, a durable competition problem of long-standing duration, and doesn't affect a large line of commerce, but yet it's diverted your resources. So those would be two areas that I would, as it were, not focus on. Third thing is, I think that the time has come to end the competition-related regulations for COVID. We get back to business as normal. Because as long as those regulations hang around, people are going to come to you with mergers and saying, yes, you recognize through state policy that there's this particular situation. Take that away and you say, well, the economy is opened up, we can go back to more normal analysis. So what then do I think that you should be doing? Well, I think, and James Hodge, I think, has sent a little question around that, is your focus should be on is on trying to get competition that has been eliminated during this period for whatever reason back into the marketplace. And then that I think is a focus on small businesses. So what I think the Commission should be doing is identifying which sectors have become more concentrated since in the COVID period. What are those sectors? Which sectors are strategic to the economy? Are small businesses operating in there? And what is keeping them out from a competition point of view? And to look at both exclusion, in other words, exclusionary acts of dominance by the dominant firms, but also to be looked, and this is the point that James was making in his question, to look at inclusion. So you've got the new buyer power regulations. Now, the buyer power of retail firms has probably increased dramatically since the lockdown has started, because many of their competition has been knocked out of the marketplace, so their power over suppliers has increased. I think that is becoming a priority area for you to have to look at in terms of inclusion or getting those small businesses back into the market. So from the point of view of looking at dominance, exclusion, and inclusion, those would be very important things. The other thing, and I think this is a point made by Tondo, is that the cases take far too long. What I liked about the Babaleki situation is the fact that you've got quite a complex case resolved in quite a quick period of time. And there's no reason why we can't apply that to other cases. In other words, it's very, very important in dealing with dominance that we get resolution quite quickly. And I think what the Babaleki case has taught is that it's actually possible to get a complicated case resolved fairly quickly, lawyers' games notwithstanding. And you can, without doing an injustice to either side, get that happening quite quickly. So those would be my suggestions.
No, thank you, Justice Manuel. These are very pointed suggestions. I think it's important that, as you highlight, inclusion, prioritization of impact, and ensuring an efficient review of matters. I will, at this moment, take 4 questions, one for each speaker, and I'll give my speakers in 1 minute each to address those questions. Kawa, do we have any questions? that you want to present to each speaker? One per speaker, please.
Okay, thanks, Chair. Yes, we do have a few questions. And the first one maybe is more directed to the acting justice. But I think also DG Kariuki can also chip in on this one, which says, can merging parties really commit to no major specific job losses in a deep recession, or at least not pull out on a commitment later? So how credible are public interest commitments which are accepted to save an anti-competitive measure?
Is that all? I want to take them all at once.
Take them all. Okay, so
yes.
This one from Shaista is directed to Dr. Lyoka. I think also Dr. Vilagazi can chip in. So the question says, Andreas mentioned state aid and the temptation for government to have a stronger role in providing assistance despite distortions created. In South Africa at the moment, state aid to SOEs is in several sectors with commercial competitors is a reality. How should the competitive distortions created by this in those industries be approached in the context of a difficult economic environment? The last one, I think the acting justice has already touched on it. From James, which says, we saw during COVID that some firms used their market power to shift their burdens onto suppliers or customers. Should we not prioritize policing unfair trading practices, especially against SMEs? I don't know if he wants to add more, or others can also respond to that.
No, thank you very much, Tawe. I will give the floor back to the panelists. I'll start with Dr. Vilakazi, then Director General Kariuki, Justice Manoi, and Dr. Lyoka. And as you respond to the questions, do also give us your final thoughts on what next for competition authorities, especially those in developing economies and Africa in particular.
Thanks, Chair. So I think the state aid or state, state support for firms issues are always sensitive and difficult ones. I mean, Padilla and Petit were saying the problem with state aid for failing firms is that it potentially prevents the kind of natural exit, the cleansing effect of otherwise inefficient firms from the economy, right? And this is coming from that place where there should be free entry and exit and the kind of traditional models of understanding how markets work. I don't want to say anything more on that, except that it's a difficult perspective to deal with in and of itself because of the economies that we operate in as well, where entry and exit doesn't work as you would expect in the traditional market models, where capital is not mobile, where the market doesn't function like we were taught in Economics 101, right? And so often some of these references are back to those principles, but I don't know if those principles apply in some of our economies. Of course they do, but there are nuances, and the nuanced view is required, as Frederick Jenny suggests on these issues. What I will say is that, and we've written quite a bit on this, I think that there is a concern that where there is going to be state aid, certainly in the South African context, I don't know if we've been cautious in terms of the types of conditionalities and outcomes that we expect to see from that aid. And I think we've written one of the chapters in the book I was referring to earlier, the Opening the Economy book, which I think is out now, speaks to the fact that, for instance, on our national airline, if you read the mandate of that organization, it has nothing to do with consumer-facing objectives or promoting more localized travel so that local economies in rural areas can start to grow and leverage tourism, etc. It has none of that. It's strategic goals that have nothing to do with your citizenry. And I think this is a problem, right? Because it means you have not put conditionalities on all that money that you put in. Now, SAA is an unfair example because they've been through a lot, but I think it tells us about how we might want to start thinking about state aid in our context, or state support, and what we require of it in return, right? And I'll make one more point on this, which is that I think there's a very good literature, at least in the competition economic space, on competitive neutrality frameworks, which set the boundaries, and I think Andreas Lund was hinting at this, which set the boundaries or provide some criteria against which you can evaluate state aid interventions. So the proportionality issues, what kind of impact do they have on competition or rivals, importantly as well. These are important frameworks that provide some guidance on these issues. More broadly, I think lastly, I think that competition agencies are in a very exciting moment. I think that there's a good chance that your African authorities are actually going to come up with very interesting and innovative ways of dealing with some of the broader challenges that our societies face. And this is the message that Prof. Fox and others have been arguing for years. And so we look forward to see what happens next, really. And the pressure, I guess, is on the authorities now. Thank you for the opportunity.
Thank you, Hardeen. And what I've seen is that I'm being crucified for a statement I made in June 2020, which I thought people had forgotten in regard to competition agencies lowering their guns in terms of industrial policy. But for sure, I still stand with that school of thought that it is important for each and every economy to have an industrial base, however small. And this school of thought, my school of thought, has been amplified by the ramifications of the COVID-19, when we had disruptions in terms of supply chain, that some of the countries which were importing even toilet papers from China, people had to procure toilet papers and fill their bedrooms. I don't know where they were living. So obviously is that I still stand with those. However, is that I'm not an advocate of total protectionism. And I wouldn't say that we ban imports, but in Kenya, we have a situation where government departments are supposed to procure local content, 40%, and then the other 60% can be imported outside the country. And this issue, especially in terms of essential commodities, obviously the current situation in regard to COVID-19 vindicated my position, which I indicated in June 2020, and I still stand for it. So whatever I'm talking about, it's not about protectionism, but ring fencing a certain type of percentage of, especially the essential facilities for people, especially whoever I'm calling vulnerable groups, the poor and also the sick, to be able to access these products. Also, what I would advise the government, total protectionism never works. I think the government should focus more on ensuring that the cost of the drivers of industrial policy is lowered in terms of the accessibility to the capital. Number two, the cost of electricity. Number three, the transport charges and also the telecommunications is lowered. Because if at all we protect our industries, or even if we ring fence them, and these costs are still high, this one, it's going to be transferred to the consumer, and they will not be able to reap the benefits what the government may be intending to reap. To conclude, is that I would like to say, like for example, now in the Kenyan economy, the schools are demanding a lot of sitting desks because children have to sit far. Should we import this from IKEA? I think there's a situation where the local manufacturers can supply this to the schools. Number two, it's also in terms of the masks, the PPEs. The demand across the whole world is very high, and the prices are going up. Why can't we have an industrial policy which is somehow supporting the local production of these, including the foodstuffs for our citizenry? Let me conclude there.
Thank you, and Acting Justice Manuel, and then Dr. Lioka. Then we'll wrap up.
Perhaps let me just repeat the question to me was, can merging parties really commit to merger-specific loss of jobs in a deep recession, or at least not renege on the commitment later? How credible are public interest commitments which are accepted to save an anti-competitive merger? Look, I think that's a very good question. I think the first point is to say just because parties give an undertaking doesn't mean that the commission or the tribunal are obliged to assume that the undertakings will be met. So if the parties are coming along and saying, I want to trade off my market power against X number of jobs, you are perfectly entitled to inquire whether this is a credible trade-off or not. And that can be done by looking at, well, where's the demand coming from that's going to support these number of jobs? If you're saying that the failing firm is going out, why are you going to get back this demand that would save those jobs? Are there redundancies? Are there internal documents of either the acquiring firm or the target firm that talked about jobs and job losses? And if you find that the undertakings are not credible, then you could say, well, we don't accept that you're actually going to be able to live up to your expectations, and not come back to us in 18 months and tell us, sorry, we couldn't keep to them, please let us off the hook. You're perfectly entitled to do that, interrogate that. And if that is the only thing that can save an otherwise anti-competitive merger, if they are not on the face of it credible, and the merging parties have the onus to satisfy you that they are credible, then you must not accept them and judge the merger as one on which there is no redeeming public interest, and therefore it must be treated consequentially in that way. So that's what I would say about that. Then there was just one brief question to me about whether I agreed with the tribunal's analysis on the excessive pricing. I don't have a problem with the way the legal analysis was made and the approach that was taken in that case. It's simply, to me, really a question of the prosecutorial resources. And the point that I made earlier is, do we divert prosecutorial resources and the tribunal's resources, which were obviously considerable to consider this case, with so many other things around at the moment? And I think this falls more into the consumer protection type of case, with these temporary price gouging monopolies, than they do in competition cases, which should be talking about more durable market power, not temporary market power. That's my own personal feeling.
Thank you, Justice Manoin. Dr. Leoka.
Thanks, Adam. So part of my question was answered very well by Dr. Vilakazi, but I think our problem is that we look at sectors versus, we look at like entities versus the sector. So we talk about Eskom versus talking about energy and the energy sector and how we're going to reform the energy sector. And when we talk about the actual sector, it becomes a lot more inclusive, rather than talking about an entity that, yes, it's a huge majority, but we're trying to chip away from that. And all the resources, or at least a big chunk of the state resources over the past 10 years have gone to Eskom. But I think in looking at Eskom, we should look at the energy sector and allocate resources to the sector rather than to this entity, because there are other players beyond just Eskom. The other thing is that we also forget that state-owned entities are part of this oligopolistic nature of our economy, and so and they do crowd out smaller players, and we need to look into that and how to break them down. I think this is a great time to have that discussion now that we have the SOE panel or council, I think it is, that can look at all the 700 and odd SOEs and look at the efficiencies there, and where there are inefficiencies, then you can start opening up the sectors and involving other smaller players. I think there's a great opportunity there. The other one is definitely, SAA, Dr. Vilakazi mentioned it. I would have rather given, funded SMEs that 10.5 billion instead of SAA, because I think we all know the inevitable, what's going to happen. It's quite inevitable. And we allowed it to happen as South Africans. About, I think 162 billion rands has gone, in financial support, has gone to 4 five state-owned entities in the past 10 years. And that is a lot of money that could have gone elsewhere. And I think that it could have been a lot more impactful than what we've seen currently. The irony is that those 4 or 5 entities are still requiring funding, including Eskom and SAA.
Thank you very much, Dr. Leoka. So it's 162 billion rand, almost down the drain. Over 162 billion rand down the drain. In closing, let me thank our distinguished panelists for sharing their perspectives on the appropriate response for competition authorities to adequately respond to the challenges of COVID-19 crisis. I know we were slightly over time. I hope you found the session as informative as I did, and do enjoy the rest of the conference. And I believe tomorrow in the morning we have His Excellency Wamkele Mene, who is the first Secretary General of the African Continental Free Trade Area Secretariat. So you wouldn't want to miss that. So see you tomorrow at 9 a.m. But before we go, let's take it back to Songezo.
Thank you so much. Thank you so much, Deputy Commissioner. You know, the reason why I put my face on video was that I was hoping you'd inadvertently come to me and ask me a question, at which point I would have just summarily ended the discussion altogether. But at the same time, how could I? I mean, how do I? And this is where imposter syndrome really kicked in. Dr. Leoka, Dr. Vilakazi, Dr. Kariuki, Acting Justice Manoya, and for good measure, a Deputy Commissioner who employs me. So I could only but sit and wait. But I think it is also true to the fact that the quality of the engagements that are the kind of questions that came through, and that the listeners have been here, have been engaging, and are still wanting more. Unfortunately, we simply cannot have more for want of time. Tomorrow does promise to be as humdinger as an engagement, as you've correctly referred to, Hardin. We've got the first ever Secretary General of the biggest trade agreement in the world. That's bigger than what NAFTA was. It's bigger than anything in Europe, certainly, and it's Africa's time to shine. Apparently it's now or never, so we will hear his thoughts on that. The panelists this evening in Kenya, Dr. Kariuki, so much thank you indeed for your time. Dr. Leoka, thank you so much for always being the voice of reason and lending your time to the Commission. We thoroughly appreciate your thoughts. Alternate member of the Tribunal, CRED Executive Director, Dr. Vilakazi, a friend of the Commission. Sir, thank you so much for your time. Twice today, you've had to bet today, and you didn't at all seem fatigued by it all. Norman, thank you so much. You're supposed to be in retirement. The next thing you go and take up a position on the bench. So much as for your contributions, continued contributions in this country's makeup. We do appreciate your time, sir. As of course is proper and protocol to say, Mr. Rashisusu, thank you so much for your time. Colleagues, let's meet then tomorrow, 9:30 sharp. All the technical challenges that could have been were not today, so well done to you as well for getting to grips with this technological age of having meetings and conferences across the continents as seamlessly as we have had them. Tomorrow is the second and final day. Be sure to tune in, as the promise is more of what was today. Goodbye, everybody.
My name is Andresa Liebenberg, and I'm a Senior Associate at Weber Wenzel. I think that the Commission should focus their enforcement action on ensuring that mergers are considered and approved on an expedited basis as far as possible. In doing so, the Commission should also engage in a careful balancing act to ensure that immediate public interest considerations do not outweigh the dire need in South Africa for foreign direct investment at this time. The Commission should also perhaps consider reducing the filing fee in respect of failing firm mergers, given that these mergers by definition would involve a target that does not have great financial resources, as well as an acquirer that would need to keep all cash resources on hand to ensure that the turnaround strategy in respect of the target can be implemented effectively and efficiently. The Commission should also commit to clear and transparent timeframes for the investigations of these mergers to ensure that the acquirer can plan accordingly and ensure that the turnaround strategy is implemented as soon as possible, or in the case where the merger will not be approved, so that the target can search for another acquirer without delay.